discussing the most pressing of topics every Friday at noon Eastern Time.
All right, well, that's interesting technical glitch. I hit play, and then it didn't play, and then it did play, and I think the stream's going, and now people are watching. Okay, it was showing 0, so I was going, what the hell's going on here? How is everybody doing? Happy to have Andrea Burkhart back, and then Ron Coleman. I think this is your first official appearance on the show, at least from the jump. I know you've been on briefly before, but great to have you.
Great, perfect day for it.
Yeah, I think so. Tell us about yourself real quick.
I'm a lawyer in the Dillon Law Group. I've been in a million different law firms before that. I'm a conservative activist of a sort. I'm very active on social media. I have a small YouTube channel, and I have a relatively large X or Twitter account. And sometimes I explain legal stuff, and sometimes I just riff. And I have a podcast.
Well, this is the perfect place.
A good explanation?
Yeah, this is the perfect place because this is what we do: is we hang out, we rip, we try to have fun with it. Occasionally, have a ton of news. Today, it's almost overwhelming. I don't even know where to start. So, I'll leave it up to you guys. We had a relatively small debate last night. This bringing up a few questions. One of which would be CNN themselves, and whether they control the rights to do it or not. From what I understand, Ron, you may have a contrarian opinion from a lot of streamers on it. Then there's, of course, the debate performance and or lack of performance. Then there are some other questions about whether somebody could actually be replaced as a candidate by the party, or if they would be forced to have to drop out. So then we got some Supreme Court decisions that came down, and there's a jury out on a extensive murder trial that has been going on, 40 days or some ridiculous amount of time? So I'll leave it to Andrea. What's the first topic we should discuss?
Well, the first topic we should discuss is how Ron here really undersells himself, because he's one of the few people that you will meet in any sort of legal capacity who has actually won a case in the United States Supreme Court. So go, Ron. He's amazing and fantastic. So let's go ahead and start with that.
Well, I mean, the Supreme Court is, I'm not one of those lawyers who's in the Supreme Court all the time. My one trip up there was successful. It is an extraordinary thing for the government to lose so consistently and so hard. One of the people in the Supreme Court advocacy business who's extremely good, and I don't want to name him, is famous for her winning streak in the Supreme Court, or her ordinary record. And I at least used to be able to say, well, that's because she almost always represented the government, and the government almost always wins in the Supreme Court.
Or are we talking Chevron deference?
Well, we're getting
we'll get there.
After the death of Chevron deference, that is one thing that I think may change a few things. Hi, Danny. Yeah. I'm Ron. I don't think we've ever met before, and it's a huge deal, and it's a reflection of the work of a lot of lawyers who have stuck their necks out on issues that have been, in many cases, politically unpopular and went against the grain. The Fisher case is amazing. It's an amazing outcome. It is something that has been part of the business litigation, administrative law litigation landscape for a very, very long time, and it's a huge development. It's
for people who might
so
not
many things going on in this country.
For people who might not understand what an absolutely massive deal this is, this decision that the lawyers are so excited about Chevron deference is done. It's one of these, maybe hyper technical things that lawyers are more excited about than people just reading the headlines. This is really going to the core of the allocation of power in government and who gets to decide what, who gets to make the fundamental decisions that actually have day-to-day impact on people's lives. Because this is a squarely dealing with the power of the administrative state to be able to decide for itself what its own authority is, what it has jurisdiction to act on, who it has authority over. Anytime Congress is less than basically 100% explicit about what its intention is. And so for decades, we have had this rule that agencies get to decide these things. Courts will defer to agencies' interpretations of the law that they're empowered to administer. And so they get to decide, for example, does the Clean Water Act apply to solely intrastate waters? Who is subject to regulation under all of these different administrative laws? And if you follow and have concern about just the massive growth of government, the administrative state is where you're looking, because that is where the overwhelming majority of law really takes place today. So I'm still processing.
You're gonna hate
what's
me.
that?
Well, we've got Kurt from Uncivil Law. He's going to be coming on, and Kurt is in love with Supreme Court stuff. And
yes.
So I definitely wanted to get his take on Chevron. I think Nate's going to be coming to talk about Chevron. So I don't want to push it too far in the future. Another thing,
Eric, respectfully, you can't push it too far in the future. We could talk about Chevron all day. Everyone has something to add. I think fundamentally, before they all come in, this is all I want to say. When you think about Chevron deference for the lay people out there who are like, I don't get why this is such a big deal. Think about when you were a kid and you went and played Power Rangers or some kind of power game out on the playground. And you always had that one asshole who was like, I have the power to have all the powers. That's basically what Chevron deference allowed for the agencies to do. It was
Calvin Ball.
Yes.
Calvin Ball, yes.
Exactly it. So just to give you guys some basic concept of what they were allowed to do. They were allowed to enforce the law, make the law. They make rulemaking decisions that govern most of your lives, whether it's the FAA, whether it's immigration, whether it's the food you consume, whether it's the shots you're forced to take, whether you name it, it's the agencies that are making the vast majority of laws. So this is going to have a huge impact on how much money the agencies get, how much Congress wants to deal with them, and whether or not Congress is going to step up to the plate and make clear laws rather than making these yada yada laws and saying, yeah, go take care of employment, yada yada, and then letting the agency just fill in the gray line. And that's where they've been making the vast majority of their money and sustaining themselves. This will bankrupt them. This is a huge win for every single American out there. This is a huge win for freedom. Congratulations, America. That's all I wanted to say.
Can you explain that more? I think it'd be great if you could explain more about the money component.
So there's money on two parts, and maybe Kurt can speak better to this, but there's money on two parts. The agencies are funded by you and I and everybody else. That comes at a federal level. They acquire that money through Congress. Congress basically says, we don't know everything about, let's say, nuclear power. So we're going to create this agency to make the rules about nuclear power and regulate all of the companies, the private entities that provide nuclear power for the rest of America. Now, if the agency decides, let's say in Chevron, where you need one more smokestack or you need to do XYZ thing, and they can go in and change their mind on their own interpretation of what that means.
It's called Chevron because of the name of the case. The name of the case that established this level of deference.
Right.
If you're wondering why does everyone keep talking about a gas company?
So they can go in and say whatever they want that rule to mean after the fact. They can do this and they're interpreting what Congress is saying. And if these companies sue, we're talking millions of dollars per day being taken in because of the way that they interpret their own rules and whether or not they assign a fine or a fee to the litigant. So when the litigant goes to sue, guess what? The court sits there and goes, oh, I agree with the agency. I don't see your problem. And that's how it works. And this has been going on for decades. And so for the first time, now that the agency knows that they have the chance to lose, they're not going to be taking on these frivolous lawsuits anymore. They're going to have to just pick and choose what cases are going to be appealed to the district court, to the federal district courts, and whether or not they want to deal with the correct interpretation, and whether or not they're going to make money off these litigants, because now they know the litigants actually have standing to sue. They know that they're likely to lose. So this is going to change their entire fee appropriation system, the way that they take money from us, the people, the way that they go and seek money from Congress, because now Congress is going to say, why do you need 1,800 lawyers to fight these battles? You're the one who's misinterpreting the law. You guys need to figure out what the hell you're doing wrong. And then the entities, the private entities, whether that be an individual who's suing in order to become a citizen of the United States, or whether that be Chevron, who's suing the EPA to say, no, we actually are following the law that was passed down by Congress, and your interpretation is unreasonable. Now, all of that's out the window, and we're finally on a fair playing ground in terms of power and the way that power is structured and the way that we fight in court. That's all I have to say.
Kurt, what are your thoughts on Chevron?
I'm so happy. I'm so happy. It's glorious. It's all my Christmases coming at once. I'm so happy to dance.
Kurt, did you see this coming? I was optimistic, but I would never have bet on this outcome. Did you see this coming?
Oh, it's been teed up for a long time. The Supreme Court had took a case about 5 years ago or so where it was teed up and they kind of deferred on it a little bit. But yeah, this has been teed up and this has been sort of heading in this direction. And I had all the optimism in the world that it was heading this direction. I was so hopeful. I thought it was going to go this way. And then it died. Chevron is dead. Brand X is dead. Skidmore is great again. It's fantastic. I'm so happy.
So just so I can get cleared up, Kurt, as a layperson, is this forcing Congress to take back some of the responsibility they've abdicated to federal authorities or agencies?
Yeah. So what it means is Congress actually, has to pass laws now occasionally, and that Congress and that courts get to decide what the law means, which I seem to vaguely recall something about it being the province of the judicial branch to decide what law means, something vaguely about that in one of the more seminal cases, something Marbury, I think. It might actually be literally chiseled into stone at the Supreme Court building, literally that phrase. Seems vaguely into mind, but yeah, it's basically in bulk. What it means is that it's up to the ultimately Supreme Court, but federal courts to decide what the statute means. So the way it was before 10 minutes ago, what if you wanted to know what authority the EPA had, you ask the EPA. The EPA is the authority to ask what the EPA has authority to do. And not just the EPA, but basically every federal agency. The EPA here is just a stand-in for all federal agencies. So if you want to know what any federal agency has the authority to do, you ask that federal agency what the authorization they've been given means. So they get to decide how much power they have. Amazingly enough, sometimes they've interpreted to mean they have more power. What are the odds? So now you have to, so instead of that, you go to court and you decide it. And it may be the case that the agency is correct. Maybe they do have the power. That's fine. Maybe that's what Congress wrote. But, it's actually up to the court to decide it, and rather than the executive branch. So, yeah. So this decision probably only matters ultimately on something like the margins. It's a 5% decision. I mean,
I disagree.
Okay.
Yeah, I disagree too.
I disagree because the agencies have been building their own rule interpretation in the gray line forever to expand everything. I'll give you a quick example. My husband, who's an immigrant, he was denied his citizenship on first glance by the agency because they said, well, you put down the wrong dates and addresses on two separate applications. They weren't wrong. They were just different because he provided more information on his second application than his first. The agency interpreted a rule that says, if you lie about being a part of ISIS or a gang or whatever else, or any sort of violence or criminal activity in your foreign nation, you are not eligible to become a citizen. The agency automatically interpreted that, because there is some ambiguity in the way that that is written, to mean any misconstruction. And by the way, it already goes against immigrants. It's already presumed against immigrants. So you have to prove that you didn't lie, even if it isn't a lie. Okay, even if it is a misspeak or a mistype, any sort of miscommunication is assumed to be a lie. This has effect too on, think about all of the federal loans that are out there and the way in which students have utilized those federal loans, whether or not they can debate this. Think about the IRS. This impacts every single one of us in so many ways. Okay, I'm done. Sorry.
How about this question here, Kurt, Andrea, whomever? Will this apply to state agencies?
No.
And this, I'm going to rain on the parade just slightly, because as awesome as this decision is, okay, let's not back away from that. It is not a decision of constitutional magnitude. This is not like a separation of powers type of decision. This is just based on the language of the Administrative Procedures Act. And so it holds open the back door. If Congress wants to go and restore this massive executive power grab, they have the authority under the way this decision is written to do that. They would just need to go, amend the Administrative Procedures Act in order to provide for Chevron deference in it. That might then implicate separation of powers questions that would have to be litigated, but that has not been decided by this decision. So it's not of constitutional magnitude. It's just statutory interpretation. States, many states, have their own Administrative Procedures Act that they've adopted, their own, little administrative fiefdoms at the state level. And so none of that is going to be affected by this decision. This is limited to the Administrative Procedures Act at the federal level.
And I don't necessarily object to that in principle, because the power belonging to the states is sort of first principle, even conservative thinking. It's like the states should be free to decide, and they're the ones with general police power. So if they, as a matter of their state law, want to give agencies more power, then I don't necessarily object to that. Let them do what they want. The federal government doesn't have police power. Police power in this context doesn't mean police as in cops. It means the general power to do stuff, the general authority to pass law. The federal government does not have police power. They only have limited power, enumerated power. So here we're just saying, okay, states, if you want to, as a matter of your state law, have stronger agencies or weaker agencies, you do you. It's up to you in your states and your sovereign capacity to make those decisions. That's cool. Here, with respect to the federal law, the federal government, the APA says it's up to the courts to decide. The Supreme Court long ago decided it's up to the Supreme Court to decide. And so it's just restoring the proper federal balance. And now it's the federal government that just doesn't have the power, for example, to determine, yes, that is swampland, or that is the waters of the United States that just happens to exist in your backyard.
Well, hold on. They do have that. They have the power. Let's not overstate it.
The fact finding they still have.
Yes.
Your ability to challenge them, however, is changed radically. And that's,
Yes.
I mean, we no one wants, and certainly not the Supreme Court, every agency decision to be second-guessed by the judiciary. Judges are notoriously bad at being experts on things that they have no real understanding of. There is an understanding that administrators in specialized agencies have specialized knowledge. But now, if the stakes are high enough, or you can get a lawyer, a public interest lawyer, or whatever the case may be, you have options to challenge these determinations. And as Danny says, they not only affect the businesses themselves, but there's a domino effect on how these regulations work throughout the economy. And also,
We lost you, Ron.
I think we lost him. Although I should note that the Supreme Court did make very clear at the end of the decision that this does not overrule any decision on which Chevron has been based. So every decision that cites Chevron is still good law. So it doesn't magically overturn everything. This is a forward-looking decision, but I'll take it. Anything forward-looking is good.
I'm going to jump in really quickly because the chat is just going bonkers and out of hand. Apparently, in the Karen Reed case, the jury came back saying that they are deadlocked From what I understand, the judge told them to go to their room and sort it out. So somebody jump in if you have any information on that. I don't.
An Allen charge, huh?
They didn't really
Yes,
give
an
an Allen
Allen
charge
charge.
though. It wasn't really an Allen charge. It was just like, I know you've been deliberating hard. Try going back to lunch and come back further. It wasn't
What's an
exactly
Allen
the format
charge?
of an Allen charge.
An
It's
Allen
basically a
charge-
deadlock instruction.
Yeah, so it's where the judge could come in and say, listen, we've spent too much money on this case. We've spent too much money on you. I know that you guys aren't getting along. We know it's a hard decision, but we believe in you and we think you guys can work it out. Now, no pressure. It literally says that. Don't feel pressured. Don't feel like there's a time issue here. Take all the time you need. But also, please, please make a decision and agree on shit. So I personally think it's unconstitutional, but other people may disagree. So long as it's limited to that and the judge doesn't incline one way or another and say you need to agree, the only issue I have with it is that it puts pressure on the minority voices. But
Isn't that a hostage situation almost, though? To be fair, if like how long? How long is a reasonable amount of time? If you have somebody who's holding out saying, "No, screw you. I believe in this particular decision. I am not changing my mind."
Right.
Up yours. Do you hold me for a month? Do you hold me for a year? What is that?
I don't know. I can't believe they're deadlocked. It's so obviously not. There's so obviously reasonable doubt here. The jury is dumb.
I think, the challenge I have here is because of the fact that we had the luxury of being able to watch this over an extended period of time, to talk about it throughout the whole process, check our ideas against everybody else who's watching it, go back and rewatch the live stream if we weren't maybe being super attentive to certain points in
Have
time.
access to inadmissible evidence.
Right.
Well, I mean, to some extent, yeah, we know a little bit about what's going on outside of the court as well. Although I'm not sure that that's really I don't know. From my perspective, I don't see that a lot of that has driven perceptions of the weakness of the case based on what was actually presented in court. But so we have all of these advantages that the jury didn't have, and I can absolutely see a situation where if you have a juror that comes in and simply hasn't been all that attentive, you just come in with your, it's not that uncommon, you come in with your perception, your expectations. It is a hard sell for a defense to convince a jury that there's been a cover-up by law enforcement. I mean, that's a hard sell. It's always been a bit of a high-risk strategy with this defense because it does suggest you're in a binary situation. You have to believe one or you have to believe the other. That's not the law. But you can just create that impression that's sort of the choice that they have to distinguish in. And so if that's what the jury is struggling with, and you have perhaps people that maybe didn't take all the notes and there's disputes about who remembers what, it's not hard to get into a situation where people are just going to become increasingly entrenched, and there isn't really a good way to resolve that.
Don't you kind of need a binary situation? I'm not an expert, but don't the juries like to know, well, if it isn't her, then what? If you're claiming she didn't do it, then somebody did.
Well, that's the question. That's the question. Do you just leave it at that? Somebody did, or do you take on that implied additional burden of solving it for the jury? It's a big sell and a big high risk. It's the distinction between relying on the reasonable doubt. Look, I don't know what happened, but the evidence is really crystal clear that she didn't do it. That's a very different case than she didn't do it, and here's who did, and they framed her.
Yeah. Or even not that it's crystal clear that she didn't do it. It's just not crystal clear that she did.
Yeah.
Because that's all we really need. It's like, you can believe Karen Reed did it, but more likely than not doesn't get you there.
Yeah.
Reasonable doubt's the question. And it's like, if you don't have doubts based on reason, I don't know what trial you're watching at. I mean, I only got into this case with opening arguments. That's when I got involved in this case. And then I kind of ignored it for a while and got back into it later. But it's like, I only have as much information as the jury has because that's how long I've been paying attention. It's like, okay, and the defense is closed. They showed me an image of the car at 5:07 in the morning where I saw quite a lot of red coming from that taillight. It's like, I'm not quite sure how it can be intact at 5:07 in the morning and also shattered at 2:30 in the morning. Those seem like mutually incompatible propositions. So that, in addition to everything else, I'm not quite sure how you don't have many doubts based on reason. So I don't know what the jury's doing. They're dumb. And in Massachusetts, they even have this stronger instruction. They talk about it being a moral certainty. This even stronger language than you would normally expect. So someone apparently is convinced to a moral certainty that she did it. I'm like, your morals suck.
Well, I mean, okay, but to pile on, with what Andrea said, I think it's really a valid point. It's hard for me to understand, like watching Rittenhouse and things like that. I feel like there's so much more information by watching the entire stream, and half these cases, like the jury's out of the room. Okay, is the jury out? Now let's really talk. And I would almost love to be able to have like a jury filter. Like, is there a way for me to understand exactly only that and be exposed to only that? And would my personal decision be very different? I don't know.
I don't see how any reasonable juror can convict. I'm with the no reasonable juror. I think that should have been dismissed at the end of the state's case. The relevant question is, could a reasonable jury convict on beyond a reasonable doubt? I think it's against the manifest weight. I think any conviction is legal error. And I think this case should be dismissed with prejudice, which I suppose even hypothetically, if the jury hangs, she could still enter a directed verdict at the end. She's not going to, but she could be like, well, I'm going to find not guilty as a matter of law, but yeah, probably not. So
she would have done that at the close.
One
of the
would
state's
imagine,
case, when they raised the motion. So I don't see that happening. No. I really don't.
No.
But it's just, again, it just comes down to what the standard is, Kurt. The standard is kind of what a reasonable juror could do, but it's also assuming that a reasonable juror could conceivably believe everything that the Commonwealth presented. Just because it seems pretty obvious to us that his arm was bitten by a dog and that doesn't fit within the Commonwealth's, framework of how all this happened, just because it looks to us.
You think a reasonable juror could believe that the car hit the arm, 7,000 pounds of car hit the arm at 25 miles an hour without leaving a bruise? That's something a reasonable juror could believe?
My point is, it's not a reasonable juror standard. They're not substituting their judgment for the juror. They are assuming that a juror could believe all of those things. And if that is the case, is the evidence sufficient? That's enough. That's enough to get over the hurdle. Just because I don't think it's reasonable, all that means is that, I can second guess the jury's decision as an outsider, but it doesn't have any legal significance to do that. The jury isn't required to be reasonable. As shocking as that is, they're not required to be reasonable.
I've got the dumb question here. Which way is it hanging? Because it sounds like everybody's assuming that the majority is saying not guilty, and there's a couple holdouts saying guilty, but could it be the reverse? Could there be a couple holdouts saying not guilty and the majority is saying guilty, which is kind of, to me, big difference.
It could be. Yeah. And we've seen juries flip in unexpected ways. The ice cream murder cases in Florida was originally 1 to 11 votes for not guilty. When they did retrial, they convicted.
Oh, they're saying
so that jury completely flipped. Well, the second jury basically completely flipped on their head, winning from 1 to 11 to 12 to 0 on the retrial. So we've seen some weird things happen, man.
6-6 though. Okay, if that's the case, that's very.
They're saying 6-6. If 6 members of this jury say guilty, that's 6 members of this jury that need a beating.
Okay, mild law from uncivil. You're putting the uncivil in the law right now. I think it's fantastic.
I need to whack them with the reasonable doubt stick until they understand what it means.
Okay, somebody else is saying nobody knows the split, so I don't even know. I just I'm just curious on that.
And it's okay because as Krauss said in the closing of the Rittenhouse case, everyone gets a beating sometimes, so it's a-okay for that, right? So hey.
All right, Ron, do you have any opinions on the case, or have you followed it at all?
Been following it? Nope. I'm just taking it all in from you guys. I don't really have much to say about criminal law. It's true that I did weigh in on the Rittenhouse case because it was there and it was a culture war case, but this kind of stuff, I rely on Nate the lawyer.
How about that for culture war that I shift to another decision that went down, and maybe you could talk about it, Ron. You've been in front of the Supreme Court. The January 6th Supreme Court decision sounds like a very, very important decision. I really wish Norm Pattis was here with us because he's been representing so many January 6th defendants.
Yeah, I mean,
it's a big deal.
It's very narrow, though, right?
I wouldn't overstate how narrow it is. I mean, this statute of interfering with an official proceeding, which was meant to deal with the destruction of evidence in the context of the Enron shredding kind of situation, to sort of heighten. I mean, that was always against the law unless you're Hillary Clinton to destroy evidence. But they made it a, they wanted to make it more of a disincentive to do that. And in order to generate a dragnet level of convictions for the January 6th events, they have applied this statute extensively against people who would otherwise would not have been found guilty of anything other than trespassing, or maybe, I mean, there are a handful of people who were more than trespassing, who were, involved in more serious crimes, but the vast majority of people have had this statute applied to them. It's going, and the Justice Department, in anticipation of this outcome, has started, including on the scheduling basis, with respect to sentencing, and even some still ongoing, to be able to
internet's rough,
in order to have flexibility, in order to have flexibility to change their strategy and not have to rely so much on this statute, because this, they have the assistance of the District of Columbia district judges who are absolutely, all in on the use of January 6th prosecutions as what they consider to be a noble use of political prosecutions to send some kind of message.
Nate, you joined us. What are your thoughts on this case and overall? Can you break it down? Can you break down what what actually happened?
One guy was suing. This is just like what Ron said. I think Ron, the guy who sued, went up to the Supreme Court. He was charged with like 6 crimes, trespassing, blah 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 blah. But there was one in particular. They actually, Bowman was, they were thinking about charging Bowman with obstruction of official proceeding. Just like Ron said, it was about Enron and destruction of evidence. So the Supreme Court said, well, that conviction, they remanded it back. And just so everybody knows, it wasn't 6-3 liberals versus conservatives. Barrett was actually one who dissented on it, and Jackson was the one who actually approved it. It was like, yeah, this needs to go back. So they sent that one charge back and said, if they can convict the person under what Ron just explained, that parameter, then that charge can go forward. But if they can't, then, and Barrett in her dissent even said, it's obvious they can be charged with going into the Capitol and doing all this. But whether this one charge was good or not was the issue. So January 6th, yes, I think there's a victory there that one of them got, I think, this victory, but this guy still has 6 other charges that he still has to deal with, and those weren't up in front of the Supreme Court. So,
what does it mean for other defendants and people who have already been convicted at this point?
If their cases are still live, then they would have the ability to bring that. But if it was part of a plea deal and they gave up their rights, then those convictions would be final. So that's the delineation.
Would there be a mistake of law basis to argue for withdrawal in this type of prosecution?
Nah, not if they pled guilty and they gave up all their rights on appeal, which would be pretty typical. If that case is closed, no, not a chance.
That sucks, though. Okay, so you're saying if you put in a plea deal, even if what you're like, I'll just throw something out there, like a marijuana case or something, or something that was illegal before suddenly becomes less legal or legal in your area. are you still having to serve out your sentence when it's not even a crime anymore for, let's say, just possession? I'm just throwing that out as a hypothetical.
You're getting into complicated questions of retroactivity and whether a statute only applies to things that are happening in the future or whether it applies to things in the past. With a decision like this, it's a little complicated because there are principles of statutory interpretation that say basically once you interpret a statute, that is what that statute has always meant. You're not creating new law. You're just clarifying what it has always intended to be. And so if there have been mistakes in that interpretation in the past, those are potentially valid issues if you can, as Kurt is saying, get past the procedural hurdles that are in place to try to prevent people from being able to undo convictions that are already final.
Is that what commutation is?
Those appeals, though, for many of these prosecutions will unfortunately, first of all, you'll make a motion in the trial court. That will be denied. Then you'll make a motion to the Court of Appeals. They're criminals. These are the people who approved the appointment by a judge of basically a special prosecutor to
Ron, you're freezing out.
So
Yeah, you're on your internet's really.
yeah, I know.
I'm sorry about that. Wow. I know I hated it because it's absolutely maddening when you're senior. You're like, I got good Wi-Fi or whatever it is. So I was asking you, maybe you guys can answer. Is that what commutation might be used for, or something like that? Like if there's a problem with one of these or a law changes, could the governor or somebody say, I'll just commute all the sentences?
That's just a discretionary. Yeah, that's the mercy power basically of the executive. That it's not unique to this situation. You know, they kind of always have that for whatever reason they want to.
But you said governor. You meant president because these are federal charges.
In DC.
Oh yeah, no, these are federal. Sorry, I was just throwing out.
So your question is, can Biden pardon them? Sure.
Absolutely.
Will he? No.
But Trump could if he gets in, and that does kind of segue in there because you want to talk about mercy and elder abuse. I don't know how many folks saw the debate last night.
I particularly enjoyed CNN's discussion after the debate. Their commentary was quite enjoyable.
The preference cascade just occurred before our eyes. No longer could this fiction be maintained that nobody is seeing what I'm seeing. Everybody had to acknowledge they're all seeing the same thing.
But it was planned. No, I'm sorry. I'm not giving him the benefit of the doubt. This was a political maneuver. This is strategy. They knew exactly how they let Joe Biden fall on his face. Why do you think they had the governor of California in the back room waiting to give commentary? No, I fully expect that Joe Biden's going to walk out on stage probably this month, maybe next month. He's going to say, you know what? I've spoken to my party memberships. And I think it's in the best interest of America that I go ahead and pass the torch to Gavin Newsom. Why do you think Xi Jinping was visiting California back in November? I said this back in November that he was going to be the one to replace Joe Biden come this election. It was just a matter of time. It wasn't when or if, it was a when. They knew this. They've been playing this game for 4 years, and I'm infuriated. I am disgusted, and I am embarrassed as an American citizen.
Well, what do you really think?
The reason why I'm skeptical of that, Danny, is simply because what last night revealed is just the fiction that these people on the stage are actually running the show. It made it absolutely crystal clear that that's not where the power resides. This is just the bread and circuses for us out here to be distracted in the process, while the people who have the real levers of power are hiding in the shadows. And so the problem is that those people that have their own vested interests in continuing this Biden dynasty, what is in it for them to step aside? I mean, I'm not ruling out the possibility that there is, palace intrigue happening. I think that's, almost certainly the case anyway. Like, even if it wasn't so obvious that they had a problem last night, but an idea that this is planned, that to me, it just would suggest a lot more, just coming together, a lot more coordination than I think you would be likely to have in this situation with the various factions that are going to be jockeying to further their own interests, to consolidate their own power. If that had already kind of come together, then it just seems to me like that would have already happened. You wouldn't have needed to go through this farce, this embarrassing charade.
I think there's a middle ground between, I think, your 2 points. I think the reason why we're seeing a June presidential debate was this was the test run. Can Biden at least get on stage and be normal for at least an hour? And if he can't, then we'd rather be able to make the change before the convention, because this is before both conventions. Can we now we
He's
can
not the nominee, folks.
Yes,
he's not the nominee.
And now we can technically make that change if necessary, and it all be legit. Then after there's a nomination, then you have a whole different problem. So I think,
I don't see how they can make that change.
Well, but before they can just nominate somebody at the Democratic convention.
But they need Biden to agree, at least under the rules.
Exactly.
The creative new interpretation of the rules.
So that's what I think happened. I think they were like, hey, let's do it in June. And the people are like, June, what are you talking about? The conventions haven't happened yet. Let's do it in June. And if you can hold up, then we don't have a problem. But if you can't hold up, then we can at least, because now think about it. This at least gives them the ability to make a change before the convention. If it was after the convention, they'd be stuck.
They had set the bar so low. You're right, Nate. All he had to do was function.
All he had to do was function.
Yep.
And everyone would have just kept asking for more and more Kool-Aid. They reached the point that the Kool-Aid ran out.
And I'm going to be very clear. I don't think Trump really knocked it out the park last night. He was up there versus the dead man. The guy couldn't speak. It's like anybody could win that debate. Like,
how do you debate him? Honestly, I thought Trump did well, because how could you debate him? I mean, if you go too hard, you're just beating him down. And I actually thought Trump was mild compared to how he could be.
No, it was the rules that gave Trump the advantage. Before, everybody thought the rules were going to hurt Trump, because the rules were about muting the mic after you finish speaking and all that stuff. Everybody thought that was going to hurt Trump. But I think it helped Trump, because Trump was always quick to give those retorts. But with the mic muted, it allowed Biden to sit there, and Trump just sitting there looking presidential, and
But Biden didn't even use his time, Nate.
He couldn't.
He didn't even use his full time. It was like he would just go, and they were like, "You have 20 more seconds, President." I mean, it's just like wow,
easy stuff. Abortion. These are easy issues. He should have that right at top of mind. Abortion, yeah, of course. He couldn't speak about abortion. I'm like, oh, this guy's done.
I did enjoy his reinterpretation of the trimester framework. That was fun.
What was that even? What was that?
What are you talking about? Oh yeah, but before we move on to Chevron, I got to take my hat off to Chevron. It was long-lived. I loved it, but it's gone now. For all you know what Chevron is.
Yeah, and can I just stick a big middle finger to my civil procedures professor? He ended up becoming my administrative law professor. And when he explained Chevron deference, I came to him after class. I said, "How is this constitutional?" And he says, "I understand, you just don't get it, but it's fine." And I went, "No, I think I understand it. I just don't think I agree. I don't understand how this is constitutional. So fuck you, Dean Dickey." Or no.
Danny, the next step for the constitutionality, we got to come for non-delegation. That's where the constitutionality question is.
But you're destroying the administrative state if you do non-delegation. Come on.
I mean, as long as we're making
Give me more. Give me more. Talk like that to me. I love to hear this.
Can we get rid of Wicker v. Filburn? Because that's fine by me.
That's my wish. As long as you're going after wishes.
Just get rid of that, and then we don't
get rid of Wicker.
Wicker,
you think I'm happy now? You'll see.
Guys,
on civil
nerding out, and nobody knows what the hell you're saying.
We haven't
actually define what the case is, what you want to get rid of. I am the dumb person here. I'm clueless.
What we're saying is Wicker v. Filburn basically said that if you grow your own wheat, if you feed your own family with your own food, the government has an interest and therefore can regulate you, because by you making your own food, you are not engaging in the economy. You're not engaging in what what we can regulate. So it's the basis of the reverse commerce clause. Someone correct me if I'm wrong.
Yes, it's
Yeah.
the dormant commerce clause.
It's the dormant commerce clause, the reverse commerce clause, where it allows Congress to come in and make rules that govern every aspect of your life. Because by virtue of you existing here, you have some kind of impact on the greater society. It is a complete
the idea is there's a market, and if there's a market for a thing, then it's an interstate market. Therefore, Congress has a hook. The opportunity the Supreme Court had to get rid of Wickard v. Filburn was Gonzalez v. Raich, and they dropped the ball. It was a very disappointing decision from Justice Scalia on that one.
Dissenting.
Very unprincipled decision, but certainly outcome driven. I mean, it would have to be. There was no way Justice Scalia was going to vote in favor of getting the government out of federal marijuana regulation. But that's then, where we're stuck with.
But
give me my marijuana.
It's funny.
It's about to be Schedule 3, so you got that going for you.
Everybody hates Wickard, but it's really Gonzalez is the case that everybody stands on, because Gonzalez is the weed case. It was like, I'm growing weed in my own house so I can smoke it, but it can affect interstate commerce in some theoretical piece. No, that was Gonzalez. Gonzalez, she was.
But it was the application of Wickard.
That's just Wickard through and through. Wickard is the poison.
Well,
non-interstate, non-commerce is somehow interstate commerce.
Yes.
So
because you have a person grow. The person was growing wheat on his own farm.
At the weed, like at its root. That's what we're fantasizing. We're fantasizing going back to a time where Congress made its laws, the courts interpreted the laws, and the executive branch actually enforced the laws. That's what we're begging for. We're saying, look, can we actually just have a constitution? Can we just go back to what our founding fathers wanted? That's why we're.
Danny, the last point you made is extremely important. Another crisis that and this is not before the court in any meaningful way that I'm aware of, but another crisis, a constitutional crisis that we're suffering from right now, is this concept that was brought in with the Obama administration and then became localized through the Soros DAs, that law enforcement agencies or particular prosecutors have discretion over what laws, categories of laws, not an individual prosecution, but that they will decide what categories of laws will not be prosecuted.
Yep.
This is such a fundamental, and this is what has led us to the woke urban nightmares of San Francisco and Oakland and Portland and parts of New York. As far as I know, it's I don't know that there's a judicial solution for it. Maybe someone really creative can think of one, but that is in addition to the things that we mentioned today, that is right now the biggest threat to the rule of law in this country.
But hold on, Ron. That you're talking about another Scalia case. There was remember the woman who had the protection order. She was in Colorado, and her husband was coming after her, and she called the cops, and the cops didn't, and he was there, but they didn't arrest the guy. And Scalia wrote the decision saying you don't have a right to police protection and the scarce resources argument, and that the executive branch can choose which laws they enforce and which laws they don't. And in that case, Scalia wrote that opinion. What wasn't it? I know. You know what case I'm talking about, right? Out of Colorado, the woman with the
yes. So that's the case
Rock.
that they relied on.
Castle Rock.
Castle Rock.
Yeah, Castle Rock, along with the DC case.
Yeah, so Castle Rock was the one that established that whole scarce resources argument for the executive, that, hey, we can say we're not going to enforce this law because we don't have the resources to put into enforcing that particular law.
But that's did it give permission for categories or actual laws, or did it say that in a given instance, government can make the decision whether or not to proceed with enforcement? But for
Castle Rock particularly, it was about, she had a judicially authorized order of protection. The police didn't enforce that order of protection, and the Supreme Court said that the police department doesn't have to enforce those lawful orders, or even any a particular law, and the argument was scarce resources and prosecutorial and executive discretion. So in Castle Rock, you're right, it's not for a category of law, but it was just for in that particular circumstance. So, but I'm expanding it to saying, if that's the case for this one law, then what makes, if they say we don't have the resources to do drug laws, for instance, like I know, like in New York,
but I think it's a line you could draw. It's a line you can draw.
You could. I'm just not sure that that's a great idea, honestly, because if we're stuck in a situation now where the existence of the law is in some way a mandate to enforce it, we've got the Harvey Silverglade problem now. We don't even know what all the laws are. I mean, we already have a problem with overcriminalization. We don't need to make this a lot worse. Some discretion to non-enforce needs to inhere in that prosecutorial role. I tend to think the remedy for that has to stay political. If you don't like how they're enforcing it, vote them out and vote in somebody who will enforce it the way you want them to.
But part of the problem, Andrea, is, at least in my jurisdiction, it's the DA who does a lot of the investigations into his own voting, right? So there's a problem there. On top of that, I was a firm advocate for actually prosecuting these cases, even though it may take up resources. And the reason for that is to make the voters recognize that these laws exist, that they will be enforced equally upon all litigants. And if you don't like it, you need to get rid of those laws. It puts the onus and the pressure back into the political realm rather than putting the political realm back into the judiciary. And that's where
that's our analogy to Chevron.
Yeah. And so, putting these pieces back in their separate and individual places. Eric, you said before, we're a bunch of law nerds nerding out. This is why, is because it has practical impact on every single citizen, whether you recognize it consciously or not. I
love nerding out. I love that. I just need to know what the hell you're talking about.
Yeah, that's what we're talking
Otherwise, it just is noise to everybody. I can nerd out all day with certain things. Get me on tech, get me
everything
on
is commerce. All the things are commerce.
Yeah, everything is
Congress
commerce.
has the ability to control all the things. That's the
So
thing.
do the agencies.
Well, we never.
What about this comment that came in? I think it's maybe a little bit back, but the clarification that the wheat it's
still Congress's ability to legislate and say your own wheat that you grow on your property for your own purposes belongs to the interstate market.
Yes.
I don't buy the distinction between he was consuming versus his animals. Because either way, the wheat grown on his farm was consumed on his farm. It is not traveling off his farm,
property,
let alone between states. So how is it interstate? And he's not buying it or selling it. So how is it commerce? It's non-interstate, non-commerce. Doesn't make any sense.
But also, so to help the audience understand, while we're all happy with Chevron, it's because Chevron was in 1984, the Supreme Court essentially gave the executive branch carte blanche to do anything in the executive agency. So if Congress passed a statute and you had an ambiguous term, then Congress said, well, whatever the administrative agency said that term meant, that's what it meant. So if you went, so there was a case in which a guy goes to court and he has his expert saying, hey, this law doesn't make this should mean this. The government comes and says, well, we say it means this. The court automatically had to go with what the government said. It gave all deference, no matter what evidence you brought, no matter how reasonable you said it was. It was whatever the government says, that's what it went. Now, why is that upsetting to us as lawyers? Is because the court is supposed to be the one to decide. It's literally there in the Constitution, in cases of controversy, if you bring in evidence and determine what these ambiguous terms mean. So the court essentially said that we're going to take that power back that we gave to the administrative agencies, so we can determine what the law actually means. Because if Congress passes a law, it's not for the executive, to the agency to determine what the law is. It's our sole province. So they essentially took that power back that they distributed to executive agency. So when you hear me say things like destroying the executive agency, that's why you have like judges for immigration court, those are actually employees of the executive branch. They're not judicial officers, and that's because the court essentially has given some of the authority to the executive so they can make those decisions and give them deference. But now that's essentially gone. But there's a whole bunch of ramifications I think people aren't looking for, because there's Auer, there's Meade, there's a whole bunch of other cases that Chevron is the pinnacle for. So I want to see how all that also plays out.
And Nate, I think such an important point about this decision is that it's not just the power being taken back, it's the responsibility being placed back on the shoulders of Congress to do the lawmaking where it belongs, because Congress is who is accountable to us, the voters. That is how we decide whether we support the direction that the law is going or not. With the administrative state, we're powerless. We're just subject to whatever who is running the show behind the scenes decides they want it to be.
But what do you think about, because for those of you who don't know, if the administrative agency passes a rule which has a force of law, and they interpret that rule, Auer then kicks in, and Auer says whatever they say it is. That I think is just as bad as Chevron. But Auer's still in place. Do you think
Auer is
now
not
goes
long
down?
for this world either? I don't
You
think.
don't think Auer is long for this world either?
I don't think it's long for this world, because even if they're in their own rulemaking process, they still have to determine whether or not they have the authority to make said rules. So, there's still an interpretation issue there that I think Chevron is the most egregious form of. But I don't think that this is going to last.
Yeah, because
They
Chevron
should have just overruled Auer.
The
as long as
plain
they're ratified.
language.
Just overruled all. That'd be great.
Yeah.
It's a hero.
The plain
here's a whole
language
list
of the decision today would not allow that, because they've made it crystal clear. The language of the APA is that all the legal interpretations still reside with the court, and so that's gonna encompass the interpretation of the rule that's adopted by the agency. So I'm gonna be with Kurt on that one. I don't see how it would continue to stand under this precedent.
And then you have Meade. And so, again, there's so many Supreme Court decisions that rely on Chevron. It's like, are all of those cases now overruled? Because essentially you overruled them all.
No, they did make that
They
clear.
said no.
Any case that depends on Chevron is still good law. Just don't do it again in the future.
They put in that little savings clause right at the end.
Yeah.
Yeah, because that would essentially destroy the administrative straight.
But you owe me a drink. You owe me a drink tonight, Nate.
That's true. I definitely do.
So we're gonna go out and party.
I used to teach administrative law in a law school, so that's why Kurt is. And I was like, I don't know how to get rid of Chevron, because there's so much built on, literally, and people don't understand. There are more administrative agencies than we can count, but most of the law that people deal with is administrative law. It's not congressional regulations, and most people don't know this. But judges don't determine it's actually the administrative state. Now that's all gone. That literally is all gone as of today. So now we're literally living in a new world. And like I was telling my wife earlier, they literally have to rewrite all the textbooks now. All the textbooks have to be rewritten, because you have 30 years of precedent that's just
40
gone.
years.
You thought Roe v. Wade was tough, but this is at another level, baby.
Yeah.
This is at another level.
Thank God. I would much rather a bunch of law students have to pay top dollar to their law professors who rewrote their own books.
A lot of law professors probably have to eat their words, right, Nate?
Yeah.
Right,
Oh my
Nate?
God.
Some law
Yes.
professors have to eat their words.
I'm eating them. I was like, I don't know how you get rid of this, because this doesn't seem.
Yeah.
It's gone.
Yay, Chevron's
I told you so. I told you so. I told you so.
I've never seen this happy that I know of on any stream.
We've been talking about this for like 3 or 4 years. As soon as I met him, he was like, that case Chevron is full of crap. I was like, damn, my name is Nate. How are you doing?
Chevron is the reason
I
I
love
joined
this
the
comment.
Federalist Society, because it was the only organization that was sitting there saying we need to do away with the administrative state, and that and that Chevron deference is bonk. And I went, oh, okay, so my stupid professor was wrong. I love Chevron. I love to see Chevron dead. It's the
So
one
is
case.
the credit for this Trump?
Yes.
Yeah, I mean, not
It was 6-3,
not
yeah.
inconsequentially.
The court.
Yeah, it's because it was 6-3.
It was
the
his
left-wing
court.
members of the court are not happy. So yet another win for Trump. The end of the administrative states.
Yeah.
Which impacts both parties equally, and I'm fine with that. Maybe
Yeah.
Congress could actually
Just
pass
to- but-
laws. That'd be nice.
But to address a question that came up before, this does not affect our states that have regulations.
No, there's a reason I moved to Texas, man. Foot traffic democracy is best democracy.
I agree with that.
Traffic.
Well, I sort of.
Isn't
I
there a
agree
reason
with it.
you moved to Texas, Nate? Might have
Yeah,
something
to
do
get
with
away from the
climate
liberals
here.
up there. You know, it's funny. Somebody. I was at the gun range, and the guy was like, "You New Yorkers all coming down here voting blue." I said, "No, listen, I'm voting red, and the reason why I'm voting red because I had to run from the blues to come here to the red state so I can pay lower taxes and have a better life. So I am voting red, and that means putting my stupid finger in my nose and voting for Trump. But
Hold on now. I'm from Arizona, folks, and I can tell you that all the people fleeing a state like, say, California, bring their stupid ass ideas over to other states, and it is a nightmare. So enjoy it while you're in Texas now.
Eric,
But
Eric, I
fight
thought you were going to
fight
say
and
I'm from
fight.
Arizona, and it doesn't matter how you vote.
Oh,
What?
oh.
Utah, you guys. Utah's the
Zing.
ugliest thing in the nation. Okay, we're not friendly. We don't have good food. You're gonna hate it here. This is the worst state. Do not come. I'm telling you, you don't like it. There's nothing. There's no support system. There's no public transport. You will hate it here. We're just full of a bunch of awful people, horrible places, nothing to see. That's all I wanted to say. I'm done.
Well, I know that people in Denver that I knew always were like, yeah, it snows. It's terrible. It's the worst you've ever seen. It's the coldest place on the planet. There's more snow than anywhere else. And then I found out that, no, it actually doesn't snow in Denver nearly as much as people realize. That it's kind of a weird pocket to where the weather is not as bad, but they are very happy with the reputation.
Colorado's great. Better state.
No.
Go there. It's beautiful. You'll love it. The people will love you there. They're very inclusive. They love everybody. Go to Colorado. You will love it.
I'm sensing Danny might be saying things other than what she might truly believe.
No, that's what I believe. This photo behind me, I know I said it was from Utah. That was a lie. This is not Utah, okay? This is Colorado. Don't even look at this.
It's
This
so
is not real
beautiful.
life.
Move to Utah.
Danny's trying to get out of Utah right now.
Exactly. I hate Utah so much. It's the worst state in the union. Do not come here.
Well, Nate, yeah, don't turn Texas to be like Austin.
Oh no, I'm not one of those. I'm voting red.
You
I
want
got
to
no
talk about
choice.
the other Supreme Court decision that came down today regarding homeless, or do we want to talk
Please
about
go ahead, Kurt. Yeah.
So there was another major decision that came down the Supreme Court today that overruled a Ninth Circuit precedent, which is the Western United States, that has been so disastrous that a lot of the left-leaning cities, including San Francisco, have been begging the U.S. Supreme Court to overrule it because of how bad it was. So let me tell you what it used to say. All right, so a couple of years ago, the Ninth Circuit Court of Appeals, which, as I say, dealt with the entire Western United States, said that if you don't have enough beds for all the homeless, then you can't punish the homeless in any way, basically. So you can't take their tents off the street, you can't remove their property from the street, you can't do anything. And this, as you might expect, exploded even more than it ever had been. Tents on the streets with all their incumbent crime and their needles and their poop and all the rest of it, right? So this became a huge problem. But the states were bound by this because it's like they can't do it, at least the Western states. So the U.S. Supreme Court today decided that, no, you can have a generally applicable law that says no camping. And they did even include a little line there, which I personally enjoyed. It's like, even if it is a student who has abandoned their campus housing in favor of doing a protest on campus.
Don't burn. That was like a burn.
It took
That's
a couple of
burn.
words there to burn the protesters for all the Palestine stuff, which I enjoyed. But basically, long story short, the Constitution is a bunch of negative rights. The government shall not. The government doesn't have to do things for you, including providing housing. So if the government says, you can't use the public land for the purpose of camping, and they apply that in a broad way, then that's fine. That is not cruel and unusual punishment. So every state, including the Western states, including LA, have the right now to take the tents and the debris and all the stuff off the streets. So we might actually be able to clean up the streets and make them such not disease-ridden, drug-ridden, horrible places to walk.
Turning
great.
back the clock on this is not going to be so easy because the social acceptance of it, the political acceptance of it, just like with abortion, it became, yes, the Supreme Court changed, it invented a constitutional right. And 50 years later, they said, oh, what were we thinking? Meanwhile, abortion is just part of our culture. It's baked in. And in the West Coast, I mean, even in the nicer California And, in the Pacific Northwest, this idea of people just get the caravans, and it's going to be real hard to back out of that.
I don't know,
Well,
man. I
doesn't
think
it
that might
help-
be true some places, and they had these grand visions of the utopia favoring the homeless when this was originally decided a couple years ago. But I think the strong sting of reality might encourage some of them to try to clean up the streets a bit more.
I don't know, Kurt. I got to tell you, at least from my perspective, it wasn't the Supreme Court that led to, the Chaz up there in Seattle. It was not.
That's a
it's
fair
not
point.
because of the law. It's cultural, and I got to agree with Ron on that one. There's a real cultural divide when it comes to homelessness and how to address it. It's a complicated problem, but Seattle didn't become the way it did just because of case law. I mean, they made deliberate decisions to have it be that way.
Well, hold on.
Sure.
It doesn't allow some communities, though, to not become that if they don't wish to.
Yes.
Right.
So that's
right.
a big
Yeah.
difference. So I understand that, yes, culturally speaking, you'll still have shitholes. That's my technical term for it. Fine. If you want to remain a shithole, if you want to do this, that's cool. But if other cities or towns or whatever, they want to say, no, we are not going to accept that, then they can protect themselves to a degree. So I feel like it's still an important decision.
It is, because the state, so for example, the state could come in and say, we're going to, ban this or whatever. And we're not going to allow for camping, right? Your illegal camping. And then the cities can come in and say, okay, how do we want to delegate the money that's being provided to us from the state and from our own coffers? And the counties can do this as well. And they can actually start looking at either creating housing situations for the homeless, or what it does is it kind of forces these local jurisdictions to decide how they're going to handle the situation. They can't ignore it anymore because there's a huge press from local leaders at a county level versus a city level. And there's a lot of inner workings there and pressure there to get things done. And they haven't been doing anything. And the cities have been able to lean back on, hey, you know what? There's not much we can do. And now this says, actually, you can do something. And so now they've lost that argument. Now they have to kind of do something. It puts political pressure on them. I'm happy with the outcome of this case, even though I'm a bleeding heart liberal when it comes to homelessness. And I don't want to see anybody. I've been homeless, right? So like, I understand from that level where it's difficult, because where are you going to go, right? And that's part of the number one problem. But if cities are forced to deal with the issue and say, you can go wherever you want, but just not here, it also encourages homeless individuals to seek out locations and jurisdictions that will allow them to sleep out on the street if they have to. But it encourages them too to get clean, or to go to facilities, or to go to these other places. There's a lot, though, that needs to change. It's not as simple as, oh, well, we'll just put them in a homeless shelter and it will be fine. I mean, the DAs still aren't enforcing laws in homeless shelters. So that's where the number one place for crime, violent crime against the homeless occurs. I don't want to go to a homeless shelter, so there's a lot to be dealt with, but at least this starts that process. And I'm glad to see at least we're kind of moving things along.
I agree with the comment that was earlier, the mental institutions. I feel like a lot of the homeless problem was created by both the left and the right. You had people on the left of the time saying everybody should be free and do whatever they want. And you had people on the right say, good, I don't want to pay for it. So it was like the worst of both sides, I feel, that allowed something to get out of hand. A lot of people who are homeless, in my opinion, well, there's a lot of addiction problems. That's an obvious one. And treatment would be helpful. But a lot of them are just needing medication. And if they could be on certain medication, it may help them to stabilize, and they may no longer be homeless. But right now, they're tossed, and I get it. I don't like them just sitting out there.
But I
Eric,
do
the
wanna,
reason why I'm going to disagree with the institutionalization is because we already have a lot of these systems in place, and these systems they're underfunded, they're crashing, they can't manage the problem that they have. Everything else being equal, I'm going to prefer a system that enables people to live with more dignity and to live with more autonomy and more freedom. So if you don't have to be stuck into a mental institution in order to receive medication and even be monitored to make sure that you're compliant and so forth, that's going to be a preferable system to me, and that's what we have. But you're not going to have to look very far to find just problem after problem after problem that people have being able to connect with these kinds of crisis services and to get somebody in a temporary bed, somebody connected with the system so that these things can start to carry themselves out. And that's such a big contributor to the problem that we have. So we just, bottom line, have to start prioritizing the mental health systems that we already have in place.
Yep. 100% agree.
I do want to make the distinction between the status of someone being homeless and putting up tents on streets, because it's still unconstitutional to lock someone up for being homeless. That was a decision made earlier. But this one was, well, if someone is homeless and starts putting up a tent on a public street, can they be cleared out? And that is, I think they were doing that in Colorado too. That's okay. So now you can't just take someone and say, we're going to put you in a mental institution. They still have you actually have the constitutional right to be homeless. It's essentially a status crime, which is unconstitutional. So
right, you can be homeless, just not here. It's the rule.
Yeah.
And so that's where I appreciate what Andrea said, because we do have systems in place, and certain local jurisdictions are more focused on it. And I think especially for places like Utah, where we tout ourselves as the most generous, the most giving people, okay, it's put up or shut up time, right? Either you're going to be a jurisdiction that deals with the homeless crisis and is willing to take on that burden and that issue, or you're not. And now cities can kind of decide and choose what they want and how they're going to deal with it. This is huge win for places like Honeytown, right? Koreatown down in downtown LA, right? All of these cities now can fight back from this deterioration on their own property and avoid a taking situation, which is what I suspect has been going on. You want to talk about some conspiracy land? I think that they're intentionally allowing homeless camps to set themselves up in certain areas so that they can say they're blighted and then come in and take those areas. And so this is now protecting against that strategy, and I'm happy to see it.
Yeah, so well, it actually is happening, like Chicago. I know Nate and I have talked about that, where they shut down all the grocery stores because, well, everybody's stealing and all that. So great, you shut down the grocery stores. Well, hey, where am I going to buy food? I've got an idea. Government ran grocery stores. So it's a perfect thing. There was a story I was listening to of an undercover agent. This goes all the way back to Arthur Bremer and George Wallace in the early 70s. But he was talking about how do you capture a tiger? And he said that the trick to capturing a tiger is essentially in India, they find the poorest people out there, the really, really destitute, and they give them pots, pans, noise-making, banging, all kinds of stuff, and they just go into the jungle and they start making all kinds of holy hell racket, and the tigers start to freak out, like, what's going on here? And they divert them into a cage. The tiger actually picks their own cage. Well, if you think about it, Chop, Chaz, all these things, they get the people to not only accept more government, but to beg for more government, because I'm scared, I'm losing my property, I'm doing this. People can see this as a long-term strategy for people to ask for more governmental interference. So I do believe what you're saying, Danny, and I think it's similar to your point.
Yeah, so we just want the right to fight back and say, look, my area isn't blighted, and to the extent that it is blighted, that blight is being brought on by the city. And I bet you could probably raise a claim now to say the city has to do something about this, or at least because of the city's uninvolvement or the city's policy, it has forced the blighted situation. Ergo, I should be able to fight back against the city, and I should be able to fight back against the blight designation and allow the city to come and take my property. That's what I'm saying.
Well, you know, that's an uphill battle because we just had this.
It is an uphill battle.
I feel like I'm in New York again. So in New York, there was a place that we all know Manhattan is like the number one place to buy land. It's if you want to buy any parcel land, it's at the top price top. So what the city did is that it had some land that it wanted to sell to Columbia. So it went and it said, you know what? This land over here is blighted. It just came in and just decided that land was in Manhattan, in the middle of that. This land is blighted. So we're going to have it at low dollar amount. So we're going to buy it. We're going to eminent domain it, give them fair market value for blighted property, and then sell it, turn around and sold it to Columbia for top dollar Manhattan prices. But the government's been doing this all. This is what they do. They did it with the railroad. This is what they do. So I don't know how you can change that unless the Supreme Court says you can't do that. One of the biggest ones was Ebbets Field in Brooklyn. They wanted to again condemn the land, but the city government was the one who stopped that. But they do it for bridges, they do it for tunnels. Whenever they want to do it, that's just par course for it. So
It will be interesting to see how this plays out. I'm hopeful. I'm really hopeful that this might pave the way for that, though.
Yeah, but then what do you talk about, like all those public works projects? Because that's essentially what they do with a lot of when they want to build a new bridge or a new tunnel. They condemn the land and buy it for the cheap, and then do what they need to do. So,
but at least they're buying it for the cheap at the cheap instead of buying it for the cheap with the tent city in front of it, right? So that's gonna bury the price even more. So that's my hope, is that these.
You know what? Yeah, well, a reform in takings law at the Supreme Court level is also about due.
Yes.
That was
yes.
Well, it's Kelo. They have to overrule Kelo. I mean, Kelo says economic underperformance can constitute blight. And so, with that, is there really any restriction on the government's ability to come in and take your property?
No.
That was a disaster.
Mm-hmm.
I want to ask one thing. I think a lot of people but people are talking about it, but they're not really talking about it a lot, is that if you look at now the polling numbers, everybody, if you listen to the Democrats, all the Republicans, right-leaning, all you guys are racist. I'm a racist, even though I'm black and I'm going to be voting red. Everybody's racist. But right now, if the polls are correct,
I'm a Nazi. You can be a racist.
I was going to say, right? Ron can be a Nazi.
But if the polls are correct, the Republican Party at this moment will have the largest share of minority vote ever in the history of the largest share of minority vote. But what does that mean? Does that mean that the argument that Republicans are racist, has that now just
hold on, Nate? Is it the party or is it Trump? Is it the party and Trump?
Party and Trump.
Trump.
They're showing the down because Trump, and they're showing the down.
So there are coattails.
For instance, in New York, the polls for the governor for the recent governor, the governor came out the lowest in history, and her polling amongst minorities is the lowest in history too. Now everyone knows Biden needs not about 90% of the black vote to win. If you don't get 90% of the black vote to win, he's going to lose. He's now at something like 79%. So he's he's really, really low. And the same with the Hispanic vote, the same actually even with the Jewish vote. It's like it's all just crashing. What do you think the political leanings for this are? And it seems to me to be tied to the immigration issue, because, like, for instance, in New York, there are essentially fights in the streets now because of the resources. The city's spending resources on illegal immigrants, housing them, giving them $600 cards and all this other stuff. And the people who are there are saying, well, what about us? Why didn't you give us these cards? We've been living here all this time. So it's kind of made this shift in policy, and even the blue states, where now you're seeing more of the minority population who are already here. Even the the Mexicans who are citizens of Texas tell me how much they hate immigrants. I'm like, you're a racist. What do you mean you hate immigrants? You're an immigrant too. Like, no, we like legal immigration. I said, you're talking red now. You're talking red.
Yes.
But what do you
Nate, I
think this shift is?
There's a lot of culture war. It's a lot of culture war. I'm in an area where, a lot of folks that I know have fled to Texas. A lot of minority people have fled to Texas, and a lot of that is because the role of the school districts. People care about their kids and what their kids are being taught, and the kinds of cultural values that are being incorporated into schools. And many of these values, they do not fly with a lot of the minority communities. I think that's a big part. There is very much a sense of preservation of your own culture requires you to abandon ship with these types of policies.
Crime is huge. I mean, crime is something that is everybody can suffer crime. I mean, it's like whatever you think about this or that, if your car's broken into all the time or you don't feel safe, if you're unsafe in your area, that's going to affect a vote, I think, more than anything. And I think immigration and crime are tied in with each other to a degree because resources are being stolen from the citizenry for people who are not born here. And that is like.
But Eric, right. So Eric, there's a political problem because we went through this cycle at the end of the 60s and the early 70s. We had this patty cake approach to law enforcement, and the cities went to hell in a handbasket.
Mm-hmm.
And Congress passed a bunch of federalized a lot of crime, which was not necessarily beneficial to anyone. The Rockefeller laws were passed in New York, and Nate knows all about those. And the city became so unlivable that we had Rudy Giuliani became famous for cleaning. You know, after cleaning up organized crime as a prosecutor, he cleaned up New York City in a way that actually Ed Koch had begun the process, to give him full credit. But in the amazing thing to say, there was a consensus that crime was bad. And the question was, how do we stop it? But going back to my earlier point, we now have prosecutors announcing that we don't consider shoplifting a crime. Okay.
Unless it's over $1,000, Ron. It's over 1,000. Yeah, then we care. But you know what? That's another dirty trick, though. That's showing.
That's a big change.
No, but crime's
that's
already
a big political change.
But here's the nasty little secret about that. By saying it's not a crime if it's under $1,000, you can then change the books and say, look, no crime. There's no crime here because you're not acknowledging it as a crime. It's really some sneaky stuff to pad the numbers. If you say something's not a crime, then you can say crime's not happening. And I think that's some of the shadiness that's involved.
From law enforcement, it's an excuse. Right. What's the excuse? And that's kind of what the Black Lives Matter movement and this kind of anti-police movement was what are the underlying reasons for crime? And they say poverty. Then they say, okay, well, if it's Black, Hispanic, and minority people. Exactly. And there's this selective prosecution, this selective enforcement of criminal activity. So if you're in a Black neighborhood, you're more likely to get arrested than if you're in a white neighborhood. So this rethinking was trying to level the playing field and saying, okay, we understand there are certain people of certain races who may be over policed. So we want to try to even a playing field. But what they didn't understand was that by now turning your blind eye to something like shoplifting, for instance, then the supermarkets, if like we were talking about in Chicago, all the supermarkets in the Black neighborhoods closed. So it had the reverse effect of now closing down all the stores in the Black neighborhoods in which you're trying to help the Black neighborhoods, with the law enforcement effort. So now you see a lot of those policies and a lot of people don't realize this, except for like San Francisco and Oakland. But in New York, they've reversed all those policies. Now if you shoplift, you're going to jail. Now because they noticed that by doing that, it hurt the very communities they were trying to help. It was kind of like a self-own. And unfortunately, now in Washington, D.C., they're literally begging for the National Guard to come in so they can at least have a supermarket in their neighborhood. They don't have to travel 6 miles for the supermarket.
Nate, that's like drug laws.
Our prosecutor, because he didn't get the memo.
Nate, by the way, it's very similar, I believe, with the drug laws in Oregon. They have reversed almost all of the legalization, or a lot of the legalization, I believe is in Oregon, because they found out everybody's dying. I think they got tired. It was like, oh, wait a minute. People are ODing like crazy. Holy shit. They're dying. I wanted to pull up this case here as the last one. See what everybody thinks about it. It's a very interesting case because I can see you can argue both sides of it.
We have this going on in my area too.
This is your area, I think. Yeah, Oregon. Oh okay. This is one of those where I think it's really interesting, and it could affect everyone because they're saying, or they ruled essentially, if somebody is not given an attorney, they have to be released if they don't get an attorney within 7 days. Now, it's very easy to argue both sides, because one side, you can say, are you kidding? They're in there for murder. They're in there for whatever. But then there's the other side saying, well, how long do you have to wait for an attorney? Isn't that our fundamental right to even have an attorney?
Eric,
Eric.
if we want to prioritize, criminalizing conduct and putting people through the court system, then we have to fund it. Period. Bottom line. It is not acceptable to fund prosecutions and police agencies to go out and arrest people by the dozens and then not provide for the basic mechanisms of the system that you need to actually be able to process those through. We have such a shortage, a public defender shortage here in my local community, Franklin County. People have been waiting months to get a lawyer appointed. They can't be arraigned without a lawyer being appointed, and there are no lawyers to give them because the county won't pay for lawyers. The county, nobody wants to come be a lawyer, a public defender in Franklin County, because it's such a terrible deal. So this is a systemic problem. This goes far beyond just not being willing to finance the attorneys to do it. We have another problem here in Washington with the whole pipeline. The opportunity that today's decision on the homelessness has really opened up is just really the only good thing from my perspective that jailing homeless people does, which is it creates a pipeline to services. You can try to divert people into treatment programs, into mental health services, things like that they are not potentially going to be able to connect with on their own. But we have such a shortage in those systems as well. You can be arrested in a crime for Washington. You can be completely incompetent to participate in your own defense. Everybody agrees with that. We don't have the resources to be able to get these people out of the jails and into the hospitals. People have been waiting months, and this has been going on for years. This is not like a surprise to anybody. We had a decision coming out of the federal courts years back now that basically says, yes, you are violating people's due process rights when you are holding them in jail for months on end because you're not funding the resources to get them into the hospital system where the law says they are entitled to be. So this is a question of priorities. It is put up or shut up time. If you want to prosecute people, you must be willing to pay for the system. Period. End of. And if you're not willing to do that, then there need to be fewer prosecutions. And that's the bottom line.
Because Stone Cold said so. You should end it with that. That would have been great.
Well, we are wrapping up, actually, Nate. Nate, what do you have coming up?
Next week we have a video with my man Ron. So me and Ron will be on one of the videos. It's a very interesting video. I have another video of a guy from USC who was so the girl, the female in the situation, begged him to come back to her dorm room to have sex with her. They were both drugged. They go back. They have sex. All of a sudden, he's charged with blank. And then the judge, they see the video, and the judge releases them, and now everybody hates the judge. And then USC is like, hey, you know what? We don't think the judge and the jury got it right, so we're expelling you from USC. So that just made this guy a millionaire. It's like, I'm calling it Con 2. It's the same thing with Con and Yale. So this guy's now a millionaire, and now we're gonna be telling his story. So that's with Chandler. And I'm gonna have my 500,000 subscriber celebration. Thank you for everybody subscribing. I don't know why you subscribe to my stuff, but I'm so appreciative. And so that's next week. And Tiffany Hinyard, we have the next board meeting coming up. So if you guys want to watch the Tiffany Hinyard madness, then and the judge also who had 2 drive-by shootings. You have the judge who did 2 drive-by shootings in 2 different states. He's up, but he's still on the bench. He's up for his pretrial stuff. So
let me guess, Atlanta? Is he out of Georgia?
No. It's an Oklahoma judge.
Oh.
He went to Texas. Somebody cut him off in traffic, so he shot at them. They just started shooting at parked cars.
Oh,
he was arrested for that. Then he goes back home, does his judge thing for like a couple of weeks, then goes to his brother-in-law's house, gets out the car, shoots up the brother-in-law's house, and peels off. So they're charging him with like 3 drive-by shootings in 2 different states. It's insane stuff. So, and he's a Republican too, so now because people are saying that I'm racist against black women because I've been doing the black, but then I do the white judges and nobody says anything. So it's a very interesting case.
Well, that's the rules, isn't it? Andrea, what do you have coming up?
Well, I'm going to continue to be on verdict watch for Karen Reed, which now appears may not be imminent. Not quite sure what to expect about that. So I'm going to go catch up on the hearing that happened today as soon as I get off here and see what's going on. But beyond that, I'm looking down the road to we're going to have Baldwin pretty soon. That one really jumped up on me.
Yes.
I was not. I kind of lost track of how soon that is, and I went and checked the docket, and holy cow, there's been 50 things filed in the past couple days as they're getting ready to go to trial. So I'll be taking a look at that. Continuing to follow Koberger. We had a hearing yesterday. We're finally at long last. We got a trial date. So there is going to be a trial nearly a year from today. And where that's going to be, we don't know. They're still anticipating a change of venue proceedings probably sometime in August. That's really the next thing on the radar for that. So come check it out if you got any interest in any of those cases.
Hey, but before you move on, for the lawyers who do live streams on their channels, I was thinking remember we did Johnny Jepp and then we were all going to why don't we just do one mass stream? In other words, everybody streams on their channel, but we can all go into one of these things and just send it to all our own channels, and we can still be doing it together. And we'll all and everybody get their super chats, everybody gets their views, and it'll be like a mass stream. Instead of that, you do it, and then there's some tension there. We can all do it together. I don't know.
If there was only a channel that had panels of lawyers normally as a center point, I don't know.
Nate, I'm totally on board, Nate. I love the whole group watch. I love having the different minds and perspectives and stuff like that. Let's make it happen.
Yeah, and we can all. But again, you'll be doing it on your own channel, so you can leave and come back. But the stream will always be going for the full Baldwin trial, and we can all, we'll all eat a little bit off it. So.
Okay, I'm a greedy bitch. How does the super chat division work then?
Whatever super chats you get on your stream
are yours.
Oh.
Whatever super chats I get on my stream are mine. You'll be streaming it on your channel.
Oh.
But it'll be like this, but you'll be streaming on your channel, Andrea's my channel.
Yeah, we'll just all be co-streaming.
Yeah,
StreamYard allows that functionality, and I could actually turn that on here.
Why are we not doing this? Let's do that.
That's what
I think we should.
I'm asking if you guys want to do it.
Yes, Nate, let's do that. Let's do it for Baldwin. That'd be fun.
You can do it on my channel, but I'll just get the big continue to get bigger. But I'm assuming if we all do it together, it'll be great for us all.
Well,
I love that idea.
I'll happily provide that here as a center point if people want to or not.
You want to host that every day? I mean, that's a lot of responsibility.
Yeah, but they have to keep that stream up every day.
Yeah.
Well, that's the tricky part. I mean, I can't host the first day or two, but Nate's a co-administrator. I can always promote somebody if they want to be on it or not. If people pop in and out. I mean, it just depends on how you want to do that.
We can use your channel's neutral ground. I'm happy with that plan.
And then everybody's channel will be able to grow because everybody will be streaming the trials, So it'll be great. And they'll all have all these personalities on there. I think it'll be a perfect idea.
Love it,
and
Nate.
then if we hate each other, we can leave.
That's right. And do your own thing.
Screw you, I'm going on my own channel.
How can anyone ever hate you, Danny?
I'm just saying, nobody.
Where do we start with the
people do
reasons?
hate me. I don't hate anybody. That's my point.
Fair enough. One question about Karen Reed for three of you, I think, are all covering it. Do you think they're going to play hardball and the jury will have to keep coming back over the weekend all day long, or do they give the weekend off and then they can just go back to the week? I'm curious how that works.
It's very discretionary with the judge in terms of making that determination of can they continue or is it at a point where they're hopelessly deadlocked? A lot of it just depends on how things unfold. If the jury comes back this afternoon and reiterates we're not making any progress, it is not likely that we're going to reach a verdict. Then it gets a little bit harder for the judge to, continue to push them in that direction of trying to get it done. So we're just going to have to see how things unfold. I know that's not a satisfactory answer, but a lot of that is in the hands of the jury and whether their perception of whether they are making any progress.
Okay. By the way, the DUI guy, I guess, tweeted earlier that he thinks that there's a plant in the jury from the Albert family. And that there's one holdout. I don't know. I'm just stating what somebody sent me in a tweet. So DUI guy, I believe, is in the courtroom for the trial. So Danny, who's your friend and what do you have coming up?
Oh, I'm so sorry. He is demanding my attention today.
Don't be sorry.
And I've tried to ignore him all morning. He's not having it. So I am also covering Karen Reed and Alec Baldwin. Hopefully, all together with Alec Baldwin. That'd be a lot of fun. I'm going to be doing a review of these 2 Supreme Court cases that just came down, and one that came down yesterday that I think is going to matter a lot. And then we're just hanging out, having a great time on our stream. We are doing political streams. I'm going to be covering all the other debates, but we're going to have to do that on X because I don't want to deal with any strikes on YouTube. So come check me out on X, follow me on YouTube, and see what we have coming up. All of my live streams are a ton of fun.
Fair enough. Ron.
Well, I'm gonna be doing Nate next week. I really don't know what to make of my life. I
Nate's a married man, though, by the way.
Wow.
I've got my podcast.
You can't
where we
recover
had
from
General
that.
Flynn's. No, that's right. I'm moving on. And
You had General Flynn on?
yeah, General Flynn is the
wow.
episode that we dropped Monday.
Oh,
Yeah,
I
and,
love
you know,
that. That'd be fun.
He look at my pinned tweet and fun. Just click your way through. He's not the most verbally articulate guy in the world, but really interesting perspective, and really interesting perspective. So check it out. And Mark Shangizi next week. So I have fun with that, and in between, I try to not commit too much malpractice in my actual legal career.
Wow. All right. Kurt, what do you have going?
Yeah, I'll be doing verdict watch for Karen Reed, and then I think after that I'm going to print out the entirety of the new Chevron decision and possibly get myself an inflatable pool of some kind and do a hot tub stream swimming in the waters of the Chevron decision as I slowly bathe myself with a ladle with the pages of the decision. Should be exciting. So you can tune in for that content, perhaps only on Twitch. Check out for that.
All right. Well, folks, thank you so much. And if you like this kind of content, first off, be sure to subscribe to the folks here. I'll make sure you click their name. It takes you right to the channel. You can subscribe. Even Nate, I know he's got 500,000 already, but hey, he can always stand a few more. And if you want to subscribe here, it wouldn't break my heart. I appreciate it very much. We do this stream every Friday. I never know who's going to come on or off, but it is always fun and always a very lively conversation. So thank you so much. Till next